Hi, I'm Wayne Zell. I'm an estate planning and business planning attorney in Virginia, Maryland, and the District of Columbia, with over 25 years of experience in counseling thousands of clients. I'm talking about the basics of estate planning, and right now I want to discuss what you should have to protect you in the event of your incapacity. We've talked about the need for you to have revocable trusts and wills and health care directives and living wills. But in addition, you need a durable power of attorney. All 50 states and the District of Columbia have recognized that the power of attorney that you may have created does not terminate on your incapacity. It allows you to appoint an agent or attorney in fact to act on your behalf if you lack the ability to do so for yourself. If you've got a spouse, you may want to appoint your spouse as your agent now. For other agents, you could specify that the power of attorney will spring into existence once you've authorized the appointment or you've been actually certified by licensed physicians as being incapacitated and no longer able to manage your financial affairs. For example, you could state in your document that you are deemed to be incapacitated when 2 licensed physicians, one of whom is your attending physician, certify in writing that you're no longer able to manage your financial affairs. If you use a power of attorney with a living trust, you can authorize the agent to move assets that you own in your own name into the trust to avoid probate. You also can appoint a guardian for your minor children. Also, you can include provisions that do the following: that give access to your safe deposit box. It allows the agent to sign tax returns on your behalf, or to settle or initiate or complete litigation that's already in play. A durable power of attorney can be drafted so that you can have the agent change beneficiaries on your life insurance or retirement plans. The agent could be empowered to make gifts to themselves or to spouses or to heirs or other loved ones. You can even empower the agent to amend the revocable trust that you may have created as part of your estate plan. Lastly, you can empower the agent to take your assets and contribute them to an irrevocable self-settled trust. This is a trust that's essentially using your assets for your benefit. It also gives the power to the agent, if you want it to convert a revocable trust into an irrevocable trust with a list of trusted advisors or trustees to assist you when you're no longer able to help yourself. This type of trust allows you to protect yourself against predators and sometimes creditors. In Virginia, Maryland, and D.C., self-settled trusts don't provide asset protection, but in some states they do. For example, there are asset protection trust statutes available for you in Delaware, Alaska, Nevada, Missouri, South Dakota, Rhode Island, and a variety of other states. These states have enacted asset protection trust statutes, which requires a local trustee and for assets to be held locally in the state of the trust formation. These assets typically have to rest for 10 years to avoid creditors absolutely, particularly in a bankruptcy setting. Speaking of bankruptcy and creditors, we're going to talk next about creditor protection.